Thank you. Good afternoon. I'm Justin Silverman, Executive Director of the New England First Amendment Coalition. NEFAC is the region's leading advocate for First Amendment freedoms and the public's right to know about government, and I'm here to testify in favor of House Bill 1738 and Senate Bill 1253. Several years ago, I attended a journalism conference and spoke to an editor at a small newsroom. This editor told me that his newsroom received a subpoena for some of its news gathering materials, but without legal counsel and the ability to navigate the court system on its own, the newsroom just provided the reporter's notes without the benefit of judicial review. There are hundreds of local newsrooms in Massachusetts, many of them that are also lacking the resources to challenge a subpoena. Many of the larger newsrooms in the states have easier access to legal counsel, but even those organizations are burdened by inconsistent interpretations of the law, shortcomings of existing common law protections, and the great financial costs that comes with defending their rights in court. In addition to this financial cost, there's the chilling effect on journalism. A source is less likely to come forward with information vital to the public's interest, and their anonymity can't be protected. A journalist may be less inclined to pursue a sensitive story if they know their sources and notes may ultimately be disclosed in court. This is the threat that at least 40 states have already identified and addressed with their own shield laws. Yet here in Massachusetts, our journalists are still operating without the protection they need, and this is reasonable protection that allows those journalists to do their jobs, but doesn't hinder a government's interest in obtaining evidence in the most serious of cases. We at NEFAC have been advocating for a shield law in Massachusetts for more than a decade, and during that time, we've seen how the lack of one impedes the work of journalists throughout the state. So we're asking you to please consider these bills, 1738 and 1253, with renewed urgency. Thank you.
Thank you. John Albano here. I thought perhaps I should address the chair's question about the difference between filing a motion to quash with no shield law and if we had a shield law here. Right now, the protections for confidential sources and unpublished information lie in the discretion of the judge. That means different judges are entitled to come to different conclusions. I'll give you a couple of quick examples. There is a case, Ash versus Dana-Farber, where the plaintiff sought the confidential source used by a Globe reporter saying was relevant to their libel case. Judge agreed, contempt finding. $1,000 a week for the newspaper, going to $2,000 the next week, $3,000 the week after, $100 and $200 for the reporter. The appeals court reversed, saying, well, this source wasn't used for the statements you're suing in a libel case on. So it got reversed, went back down to the Superior Court. Plaintiff said, well, you know what? I need this source for the claim against the hospital, that the hospital breached my confidentiality rights. And the trial court said, I agree. You didn't talk the last time. I'm going to enter a default judgment on your libel case because you would not reveal this source for the plaintiff's Dana-Farber case. Case went up to the SJC. The SJC said, you know what? That claim of breach of confidentiality against the hospital, that fails as a matter of law. But you guys still violated a court order, so the default judgment is just fine with us, even though the source had nothing to do with the libel case and the other claim had failed. Having a shield law with clear standards avoids leaving these decisions to the discretion of a judge. Thank you.